When we talk about access to justice, I don't intend to read the article in the CRPD, but there is a separate article on access to justice in Article 13 of the CRPD. One of the reasons why that's there and what it contains in it is because of how difficult it is historically persons with disabilities have found it to access justice. And so the first subsection of this article directs states towards ensuring effective access to justice for persons with disabilities by providing procedural accommodations. Now, what I want to point out there, and it may come up later again, this is the one article in the CRPD which doesn't use the phrase reasonable accommodation, which allows for some flexibility upon the state about when to provide such accommodations and not. And the reason for this is that without unqualified access to the accommodations required for persons with disabilities in the environment of legal processes, it is impossible to participate in a way that is meaningful. And that's very important, because if we want to think about the results that we're getting in courts, and there have been complaints about that, and we've discussed it even in this session, we need to think about, firstly, what is happening in courts and how many people can effectively access justice and participate in processes. The second article directs itself towards basically what the International Commission of Jurists globally is known for, which is providing training and education for judges and lawyers so that they can do the work. And it's no secret that in almost every country in the world, disability in general and disability rights is not well known and understood by judges. Judges even making their best good faith efforts to understand laws, to understand society, and to understand disability might be starting. Many countries, a judge gets appointed at the age of 50, round about there, maybe a little bit earlier, to understand for the first time this range of issues in their lives. And this causes a very big problem, and of course the ICJ advocates for the training of judges and lawyers on the CRPD and disability more generally. We do quite a lot of that all around the world. On access to justice, there are these principles and guidelines developed by the Special Rapporteur, and Alberto, who was here, was working for the Special Rapporteur when those guidelines were developed. There are principles and guidelines on access to justice. If you are working on forced and compelled treatment, it may be that these don't fall within your notice, even if the principles of the CRPD Committee on deinstitutionalization do. But there are many countries in the world in which access to justice and institutionalization or forced treatment are directly connected. Because, as I said, the experiences in courts are often the places where people are institutionalized or are prevented from representing themselves and then become institutionalized and are forcibly treated. And these principles, I can't go through all of them, but their focus, and I think our focus is properly on in this environment, a large range of justice actors. So not just judges, and not just lawyers, but prosecuting authorities, officials within the government, court clerks, all of these. And they focus on the provision of procedural accommodations and ways in which this can be done. I want to emphasize one, which is the role of intermediaries in courts, justice intermediaries, to assist and support persons with disabilities in order to be able to communicate effectively with courts. And here in these principles, again, the training of judges and lawyers is very widely emphasized, because you've got to remember, again, that the judges and lawyers, they're making the decisions that we don't like. The image that lawyers and judges, especially judges, allow for themselves to be taken in societies is sort of like these, philosopher kings and people who are very wise and who know a lot about a lot. But the fact of the matter is that most of the time, because judges work on law of all kinds, when a case comes before them, they don't know anything about the issues that underlie it. And we really shouldn't be thinking about judges as superhuman or incapable of not understanding things.